Okay, so welcome everybody. Thank you very much for giving up some time this evening. For those of you that don't know me, my name is Nick Kay. I am a board member of the National Pharmacy Association, and I'm delighted to be chairing this evening's meeting. So we're going to be hearing from a couple of great speakers this evening. So we're going to have Gareth Jones, the head of corporate affairs, to give a net update on where the NPA is and what the NPA is up to at the minute. We've then got Sutherman from Alliance Healthcare, and thank you very much, Alliance Healthcare, for sponsoring this evening. And then we're going to work to Alice from WorkNest to give us an update on employment law and some of the bills that are currently coming through Parliament, which I know can be an absolute minefield. So really, really grateful to get that presentation. We're going to have Q&A and the chat open. We're going to Q&A at the end, but the chat open throughout the evening. Any questions, then please just put them in the chat, and I will let you ask the speakers any questions you like at the end of Alice's presentation. So without further ado, thank you very much again all for attending, and I'll hand over to Gareth. Thank you, Gareth.
Great, thanks, Nick. Hi, everybody. This evening I'm going to give a brief update on NPA advocacy activity, the campaigning work that we are doing on your behalf to try to get the best situation in the external environment for our members. So next slide, please. I'm going to start off just noting the recent developments. So both the publication of the independent economic analysis and the publication of the 25, 26 and 23, 24 funding settlement for community pharmacy. And this slide really puts it all together. It shows actually what the financial settlement is, and actually then what the gap is to the funding suggested in the independent economic analysis. So the blue bars there are the funding provided by the NHS for community pharmacy over the 3 years, 23, 24, 24, 25, and the current year, 25, 26. And to be, I suppose, on the generous side to government, we've also included the written off margin in that calculation for the funding for 25, 26. And then the orange is the missing sum, really, because the independent economic analysis showed that in 23, 24, 5 billion was due. In 24, 25, it was almost 5.5 billion, and around about 6 billion in the current financial year. So that's the view of independent economists who are commissioned by NHS England to go away and find out what the cost of delivering the community pharmacy service was. So those are the two developments that came within a few days of each other, right at the end of March. Obviously, we then had to consider how the NPA would respond to them. Next slide, please. So before saying where we are going forward, I just thought I'd take a step back and talk about the last year. We've undertaken an awful lot of campaign activity to ensure that community pharmacy is in the news, and that the funding problems are understood by the public, and by getting it into the newspaper and onto the TV, showing politicians that community pharmacy will stand up for itself, will raise these issues, does have the ability to cause challenges for ministers. So this slide here shows Day of Action delivering a petition to Downing Street, Nick appearing on the Today programme, and that was our battle bus out around Westminster, taking the message into the heart of Westminster. Next slide, please. And accompanying those activities, lots and lots of media activity. We've hugely increased the media activity we've been able to achieve over the past year. And in fact, just this year to date, we've already had 640 national media mentions. And it's not just about talking about the funding issue. It's just getting pharmacy out there and noticed. Not all of our stories are about funding. Recent ones have been about unlicensed medicines for hay fever and the overuse of antibiotics. But all these stories serve a purpose. They get community pharmacists on the news. They get ministers, civil servants, MPs seeing community pharmacy on the news, and obviously we can put in the funding messages as part of that. Next slide, please. So when that announcement was made, that there had been what was a significant uplift to community pharmacy, but still an inadequate one, um, we had to make a decision about where we would go next. Having balloted members, we had a very high turnout for this sort of ballot, of well over 60%, 99% of members in favour of taking some action. Um, we had to make a decision about what the best thing was to do, whether it was to press ahead and actually call for collective action or to pull back from it. Um, Now, the view we took was that the threat of action was a very effective campaigning tool. It allowed us to get an awful lot of attention, and from ministers Wes Streeting and Stephen Kinnock themselves. So it helped us raise the profile of community pharmacy. But for a couple of reasons, really. Government had actually made a positive step towards community pharmacy, the biggest uplift, the only uplift in over a decade, um, and making very positive noises about where community pharmacy was going. But also actually that there is going to be no uplift the next year. Our opportunity now is to try to influence the 26-27 funding. So we felt that we would achieve more by not pursuing collective action and by reopening lines of communication with ministers. Because when you're taking action, ministers won't speak to you. Um, so on balance, that was we felt the right thing to do. And actually, you can see just that announcement was covered as a major story in the Daily Mirror. And Stephen Kinnock was actually wrote an article to go alongside it, actually saying he was pleased that we were not pursuing that, and actually wanted to talk to independent pharmacy about where community pharmacy goes in the future. I mean, subsequently we've had a letter from him asking to meet us to talk more about how community pharmacy can be supported, how community pharmacy can be reformed, how we can make community pharmacy sustainable again. Um, so it was a difficult decision, lots of conversations about it, but this is part of a long-term campaign to improve the sustainability of community pharmacy. Um, Calling a ballot was a successful tactic, but now taking the opportunity to speak to ministers is the right tactic. I mean, some people describe it as effectively changing lane, still heading in the same direction, still the same campaign, but with different tactics. And long-term campaigns they need changes of direction from time to time to actually maintain momentum. So next slide, please. So, having explained that we weren't going to pursue collective action, I'm now going to explain where the campaign activity goes now, because the campaign is as strong as it has been for the last year, as I say, but a different approach from now. So first I wanted to show you a new infographic, which we are publishing this week. And this is something in particular we think will be useful when speaking to MPs, because they obviously don't have a lot of time to absorb detailed information about community pharmacy. And in this one page, we capture a lot of the things that we need everyone to understand. So on the left-hand side, we're talking about the share of the NHS budget provided to community pharmacy. So historically, it was 2.5%, and now currently it's slightly increased to 1.7%. So we are a huge amount down on historical share of the budget, and that's an important point we want to make to people. On the right hand side, we want to show that the funding this year is about 3.5 billion, but that is an awful long way short of the 6 billion which NHS England's independent economic analysis showed was the sum needed. So we've therefore highlighted what the funding gap is, and it's a very significant funding gap. We're highlighting the fact that 1,300 pharmacies have closed, that there's a 45% underfunding of community pharmacy when you look at the independent economic analysis and actually what community pharmacy is getting. We're pointing out that 98% of pharmacies are not getting the cost of the service that they're providing. 47% are loss making, and 78% of pharmacies are not sustainable. So these are all the key messages that we think we want people to take from that economic analysis, which, as we stressed, was independent. It wasn't done by pharmacy. It was commissioned by NHS England, and it was delivered by independent expert economists. So this we will start sharing this tomorrow, and it's for all our members to use if you've got NP meetings or if you've got any other local stakeholders that you want to talk to about the challenges in community pharmacy. This is will hopefully be useful to do that. And in fact, we're sharing with the LPC network tomorrow as well, in case they want to use it in their local engagement. Next slide, please. And something else that we brought out this week is our review of the independent economic analysis. It's a very long, detailed, and highly credible document, but it's 150 pages long. We know a lot of people aren't going to have time to read that, be it our members, and part of the reason for producing this document is to give members a shorter version to read, so you get the key facts without having to wade through 150 pages. But also, we're taking this document to the MPs, ministers, civil servants who are interested in pharmacy and would be prepared to spend a bit of time getting to really understand what is in the independent economic analysis. And we've made a few recommendations. The first one is actually that the numbers should be rerun now that we've got the settlement for 25-26. The economists should go back and actually work out if that settlement means that fewer pharmacies are no longer sustainable, or fewer pharmacies are loss making, because if those numbers haven't changed, actually government hasn't achieved an awful lot, even though it has given us a proportionally large uplift, but it reinforces the point that much more is needed. We make the point that there needs to be contract reform. The contract is not fit for purpose. We want government to be thinking about that, involving pharmacy bodies and thinking about how it ties into the GP contract as well. And actually, part of the remit of the independent economic analysis was to look at the cost effectiveness of clinical pharmacy services. And they basically didn't do that. They ignored that part of their remit, and we're suggesting they should go back and complete that piece of work, because we believe that will show that many services can be delivered very cost effectively in community pharmacy, and therefore there's a reason to commission more from community pharmacy. Next slide, please. And high profile media activity remains part of the campaign strategy, and this is coverage literally from the last 2 to 3 weeks. You can see Olivier, our new chair, was on the Today programme talking about weight loss. We've had stories, as I mentioned before, about hay fever and unlicensed medicines, about all the demands on pharmacists to supply antibiotics, all the incorrect demands on pharmacists, and also pharmacy closures. So we've got Today programme, BBC Breakfast in there, as well as The Sun and other newspapers, and STV in Scotland as well. So whilst we're not seeing collective action, we are ensuring that community pharmacy gets in the media just as much as we've been doing so in the last year. Next slide, please. And really, our focus is on influencing Treasury, Wes Streeting and Stephen Kinnock, 3 key decision makers. We've had meetings in Treasury, and we're taking back further evidence to them as we gather more evidence, economic research that we're undertaking with the York University, because ultimately Treasury controls a lot of this. Treasury controls actually the global sum and how much money is available to community pharmacy. Wes Streeting and Stephen Kinnock, I mean, they do say the right things about community pharmacy, and actually, although the uplift this year was nowhere near as much as was required, we still know that Wes Streeting and Stephen Kinnock had to fight to get it up even to the level that it reached. But working with them, trying to influence the comprehensive spending review, which in about 3 weeks' time will be released, and will set out government spending for the next 3 years. That's key. And once the spending review is announced, as I say, second week of June, then lots of internal battles start within government about how that money is distributed within the department. So, it'll be clear how much money the Department of Health has got, but we will have to be working with ministers and officials to try to make the strongest possible case for a significant additional tranche of money for community pharmacy for the next 3 years. And working with Wes Streeting and Stephen Kinnock over the coming months is going to be incredibly important for us. Next slide, please. And finally, just to summarise, I think our campaign activities, we've had over 2,000 now national media mentions. Well, we had 2,000 in 2024, already had well over 600 in 2025 to date. And we think it's absolutely key to ensure that the profile of community pharmacy is as high than it ever has been before. We're not always out there talking about pharmacy funding, but we're always talking about something that links back to pharmacy and shows the importance of community pharmacy within the NHS and to wider society. And that helps to build a really strong platform to make really effective lobbying points. And we have it, we've through the NPA, we've had the overwhelming majority of all coverage for community pharmacy. We think it's really, really important this time. And we put an awful lot of resource into making sure that community pharmacy is in the news very regularly, supported by great media spokespeople, our members, including Nick, who's on this call. So that's all from me. I think we'll have questions at the end, but so at this point, I'll hand back to Nick.
Yeah, thank you, Gareth. A huge amount going on. Really, really proud of all the work that's going on. There is some questions coming in the Q&A, which we'll pick up as we go through. But again, any sort of more detailed questions, please hold them for Gareth, and we'll do that at the end. So thank you very much, and the team for all their hard work. Without further ado, I'll hand over to Sutherson, and please update from Alliance Healthcare. And again, thank you for sponsoring the evening. We're very, very grateful. Thank you.
Hi, everyone. My name's Sooth from Alliance Healthcare, Key Account Manager. Just waiting for the slide to pop up. So I think there's a little bit of a lag on my end. Perfect. Yeah, so as many of you are aware, Alliance Healthcare, leading provider of pharmaceutical wholesaling, logistics, and clinical trial support. And we've got an innovative healthcare solutions to independent pharmacies and manufacturers, pharmaceutical manufacturers. So our purpose is to help build and create the world to live healthier and happier lives. And we're proud to be a good force for contributions to healthy communities and inclusive workplace. Next slide, please. Oh, apologies. It's a bit of a lag on my side, so I can't see anything. So NWOS is one of the market leaders in the supply of surgical appliances. A lot of you are probably aware it's a registered DAC as well, with over 30 years of experience. They specialize in continence, ostomy, and wound care products. As many of you would understand, with surgical products, especially with clawback, there's a very minimal margin being made, and at times probably not even breaking even. So with NWOS, you've got trade and you have your agency, and what we try to do is make sure that you can best profit from that by using agency. And again, that's by having less space, using your clean scripts, improving your cash flow. And with Alliance Healthcare, it'll be in your next day delivery as well. So again, it's an easy and convenient way of ordering, saving you much needed margin, and obviously streamlining the process in the same time as well. Next slide, please. And switch. So that's the order management system. And I think many of you are probably aware, a lot of it is about time saving at the moment within pharmacies. You guys are out on the field all the time, and you're probably aware of how busy it is and about the services that you have to push to really start driving your profits and kind of getting other income. So order management systems are really popular at the moment, and Alliance Healthcare have used Dataplast and partnered up and created Switch, and it integrates with your pharmacy, with your PMR, to kind of give you product level ordering control. So the best bit about having an order management system is, again, setting the rules that you want, tailoring it to your business needs and the way your business purchases it. We've got the warehouse feature, and that's kind of an exclusive feature on Switch as well. And again, it helps if you've got a number of groups, a small amount of groups, or a few shops really, that you can really interchange your stock, and it really just helps you kind of be in control of the whole process. You can check prices. As we know, price is key at the moment, and it's a very competitive market. So having a system that can manually, automatically check your prices as you order, again, it's a much needed system, and it's about time management as well. Takes you some time to kind of manually go through these orders, whereas if you've got a system in place with rules set up, you save a lot of time, and then again, that time can be used elsewhere in a much efficient way. And again, reporting and visibility, a lot of it again is being done at such a fast pace, it's very difficult to always keep on track, especially in the pharmacy field. So again, having that visibility, making sure that you can set up reports, and really being in control. And I say control again, and that's the main kind of point, is to really know what's happening within your branches, within your pharmacies, just so that you've got that kind of sense of, right, cool, this is what we're doing, this is how we can push and kind of just delegate and just get that support. And with Alliance and with Switch, that's something that we want to try and achieve and help you guys with as well. Next slide, please. And OptiTote. So this is something that we've launched. It's a semi-automated repeat dispensing solution. So again, you've probably heard of a few different options on the market, and OptiTote is Alliance Healthcare's version to kind of help support and have another option available. And again, it utilizes barcode scanning technology and really streamlining the dispensive process, and just keep everything, again, time management and making sure things are done in an efficient manner. So what would happen is Alliance would be dispensing your healthcare stock by delivering your repeats in totes ready for collation and dispensing for patients. Again, this is a really big, again, key process, and about time management and making sure that your repeats are done, reliable, ready for your patients. And again, that time that you can save here, utilize elsewhere efficiently. And there's a few options here. So again, simple, no need to put stock away or retrieve for dispensing. It comes in your specific totes ready. Easy to use, it's safe with additional accuracy. Again, with these sort of systems, especially the semi-automated part, there's loads of barcodes and loads of triggers that you have to tick in order to be able to dispense. So again, very, very, very rarely can you make a mistake with software like this. And again, that helps with time. And efficiency, as I've mentioned before, again, frees up your dispensing team, your pharmacist, again, can focus on services or anything else that you'd like to do within the business to push it, when this can all be done in an automated kind of basis. And again, value, it offers potential new business opportunities by reinvesting the time. So again, it's all kind of coming back to that time option. Any innovative solutions that help keep patients close to the heart of the pharmacy, and again, spending more time with the patients, and then that way you can kind of dispense as well. So with OptiTote, again, we've launched that, and it's something, if anyone is interested in a demo or a bit more information, please drop me a comment on the chat today, and we can kind of take you through at the end. But yeah, that's with our OptiTote system. Next slide, please. And yeah, that's the end. Thank you, everyone. Thanks for listening. Sorry for the small delays. I was waiting for the slide to come up. But if you've got any more questions, please let me know. Drop it in the chat, or please just take a picture of the email address there, and more than happy to take anything by email as well.
That's great. Thank you very much for the
Thank you.
update. Thanks very much for the update. Great to see all the different things you're trying to do to release that pharmacist's time and the team's time to use it more efficiently. Yeah, lots of innovation there. So please do ask the questions. And again, really grateful for the sponsorship. So thank you very much. So I think now, without further ado, we'll hand across to Alice to get the employment law update. So Alice, thank you very much.
Great. Thank you very much, Nick. Okay, so thank you all for letting me attend this evening. What I'll be covering is I'll be focusing on employment law updates and key changes that are afoot that are going to be impacting NPA members, specifically in relation to the Employment Rights Bill. So my background, my name is Alice Breckenridge, and I'm an employment law advisor at WorkNest Law. I am part of the partnerships team, and where we provide expert support to our partner members, including employers who are part of the NPA. So my role involves helping our members achieve their goals whilst ensuring legal compliance and mitigating both legal and reputational risks for them and the business. In the webinar today, we won't be covering every single topic in the Employment Rights Bill because it's just too vast, but we will zero in on some key changes that will significantly impact NPA members and explore what these changes imply for you and how to prepare for them. And I will be taking questions at the end. Okay, next slide, please. Okay, so now that I've introduced myself and outlined the scope of what we'll cover, let's move on to the content. So we'll first examine where the Employment Rights Bill stands today. So it's currently in the House of Lords and it needs to go through a parliamentary process before it becomes finalised and introduced as law. We'll explore some of the key proposed changes, including establishing unfair dismissal as a right from day one, banning exploitative zero-hours contracts and ending fire and rehire practices, to name a few. Typically, legislative changes occur at a measured pace, usually as one at a time. However, this is an unprecedented scenario, and the bill proposes 28 amendments with more government initiatives on the horizon. There remain areas of uncertainty since, as mentioned, the bill hasn't yet received royal assent, so it's not come into play as of yet, meaning the finer details could change and further regulations and guidance will be needed after royal assent to ensure that employers can practically navigate compliance and the changes. So finally, we'll consider some practical pointers as well from a pharmacy business point of view and to help you prepare and identify key considerations for when these changes do come into effect. Next slide, please. Okay, so having outlined what we'll talk through, let's have a look into the origins and the driving forces behind the Employment Rights Bill. So even before Labour's election victory in July last year, the current government was vocal about its intention to bolster workforce protection significantly. So this committee was clearly, or the commitment, sorry, was clearly articulated by Angela Rayner during the Labour Party conference in September 2024, as shown in the slides. And since then, the government has consistently emphasised that Labour is delivering the biggest update to workers' rights in a generation. And the bill's evolution thus far indeed reflects the ambitious promises, signifying a once-in-a-generation upgrade of employee rights. Next slide. Here's the list, or part of it. So as we transition from understanding the bill's context and motivations, let's have a preview of some of the key topics that it covers. Before we delve into the specifics, this is a snapshot of some key areas within the bill. We won't cover everything today, as I mentioned, but it will prepare you for key points that are on the horizon. In regards to the proposal to ban zero-hours contracts, and it has been a prominent agenda item, although there's been considerable media coverage suggesting an outright ban, it's not entirely accurate. Instead, the bill will introduce obligations for employers to offer contracts that actually reflect the hours that the employee is working in practice, and it will provide compensation for curtailed, cancelled, or changed shifts at short notice. And we'll explore this in a little bit more detail shortly. Ending fire and rehire. So this is the practice of terminating an employee's contract where the employer initially sought to vary the terms and conditions. making them less favourable when the employee has initially refused the change. The employer will then rehire the same worker on the new, less favourable terms, or hire someone else to do the same job on lesser terms. And the bill is proposing to make this a day one right, where it will become automatically unfair to dismiss an employee in this manner, unless a limited defence applies. So the limited defence is that the reason for the change is to eliminate, prevent, significantly reduce, or mitigate the effect of any key financial difficulties at that time, and the employer could not reasonably avoid making the changes. Okay. In regards to the day one rights, so additional day one rights will encompass unfair dismissal, which is a significant change for employers. As the current requirement, employees need at least 2 years service before they can raise that claim. That's proposed to no longer apply. Day one rights will also include several family-friendly entitlements and changes to statutory sick pay, which is another big one. So we will delve deeper into the specifics of the statutory sick pay because it does pose financial implications for many employers. Notably, the requirement for average qualifying earnings to be eligible for the SSP will be eliminated, and it will be payable from the first day of absence. The flexible working changes, that's not too onerous, and that's not too big in comparison to some of the other proposals. So what the proposal for this is that if an employee puts in a flexible working request, the employer will still have the 8 statutory reasons to reject it. You'll just need to explain why it's reasonable to refuse that request. And many of you will be doing this already. Okay. In regards to protection for employees who are having a baby, so we already had the enhanced increased protection for pregnant employees in terms of redundancy, and that ends roughly 18 months from the date the baby is born. So that protection for pregnant employees is to have first refusal on suitable alternative vacancies in a redundancy process. This protection, the bill is now proposing to extend this to other types of dismissal and other types of family leave, which we need to be confirmed. We need the finer detail. There's also a proposal to introduce a single enforcement body, and that's proposed to bolster workplace rights enforcement and alleviating pressure on tribunals and allow employees easier access to knowledge on their rights if there have been breaches for things like national minimum wage or unpaid statutory sick pay. There was also a lot of changes initially proposed regarding larger redundancy consultations. So currently there's something called collective consultation, which is triggered this process when you're proposing to dismiss 20 or more employees within a 90-day period at one single establishment. And that involves electing representatives, set timeframes, and government notification of what you intend to do. But the establishment element here could be a company or self-sustaining branches within it. The original bill had proposed to remove that establishment element of the redundancy, the collective redundancy consultation. However, it's done a little bit of a U-turn in that that's no longer going to be removed. However, it has been changed and the original establishment test will still remain, but the bill will have the power to issue further regulations to set an alternative threshold. So to review the trigger point of dismissing 20 or more employees within a 90-day period. Changes for trade unions are also on the horizon as well. So plans to enhance trade union involvement, including providing employees with a statement of rights to join a union, allowing workplace access upon request from trade unions, and lowering recognition thresholds. There's also consideration for electronic balloting. At the moment, it's only postal. But we will move on to have a look at the actual progress of the bill and see where we're at. Next slide, please. Okay. A bit of background in regards to the Employment Rights Bill. So in May 2024, the Labour Party issued their paper Plan to Make Work Pay. This was their pledge to introduce legislation within the first 100 days of government to better support working people, to boost wages, to make work more secure, and to ban one-sided flexibility, giving workers a voice at work and enhancing family-friendly rights. Labour were elected in July 2024, followed by the King's Speech, which reaffirmed the government's commitment to make work pay and legislate to introduce a new deal for working people to ban exploitative practices and enhance employment rights. The 10th of October last year, the bill was issued, providing the legislative framework to put the new government's plan into action. So the bill has to pass through the parliamentary process, as mentioned before it actually becomes law. And it needs to pass through the House of Commons first and the House of Lords before finalising. It recently passed through its third reading in the House of Commons on the 12th of March and is now within the House of Lords. I'll not go into too much detail regarding the ins and outs, but it's well underway. Both houses have to agree the exact wording of the bill before it can be given royal assent and become an act of parliament. So it will ping pong between both houses until it's agreed and finalised. Once the bill is finalised and given royal assent, a commencement order is then issued, and that details the implementation date, with most provisions in the bill requiring further regulations to bring fully into force. So that's the information as to what employers need to do to adhere to these new rules. Likely to be brought in at various stages. Some potentially could be this year at a push, but most likely these won't be in at the earliest until 2026. And the government has said that the unfair dismissal rights, which are one of the big ones, won't occur until at least autumn 2026. So watch the space, and the progress of the bill can be tracked on the official UK Parliament website. Next slide. Okay, now we'll look at a little bit more detail in regards to the content of the proposed changes. So we'll start off with the day one rights. So we'll move on to one of the main areas for change. There is a quote on the slide which refers to the promise by Labour in their New Deal document, which accompanies the bill, to give workers day one rights for unfair dismissal, parental rights, and sick pay. And so far, they certainly seem to be delivering on this. Okay. Right. Moving more into detail for the unfair dismissal. At the moment, as you know, in general, there are a few exceptions. So an employee cannot claim unfair dismissal if they have less than 2 years service, which I'd highlighted before. The 2-year qualifying period is proposed to be repealed so that all employees will have the right not to be unfairly dismissed from the first day of their employment. The government has made it clear that this will not apply to someone who has been offered a job but not yet started work. So the day one right for those employees who have started work day one onwards, not for just an offer. The government is clear that it won't come into force any sooner than autumn 2026, as mentioned, and there will be a probationary period, which is referred to as an initial period of employment, during which there will be a modified dismissal procedure with a lighter touch step, which will apply to the legally fair reasons for dismissal. So things like conduct or capability or illegality, but it won't apply for redundancy. For redundancy, you will still need to follow a full fair process from day one. The proposal for the probation period is anticipated to be 9 months to give employers an accurate timeframe just to assess whether they think that that individual is suitable. And there will be consultation with key stakeholders on both the probation period and the lighter touch procedure and what that looks like. The government also intends to consult on the compensation regime for successful unfair dismissal claims falling within the probation period. And it is a significant change and it will impact all employers. Just by changing it to day one qualifying, right, it will increase employment tribunal claims. We'll have more individuals chancing it and raising this. And the time limit to bring claims as well. So the time limit to bring claims for unfair dismissals and all other claims, such as discrimination, will be increased from the current 3-month period to 6 months, and that in itself is likely to increase the number of claims. And a practical pointer to consider from an employer's perspective for this, record keeping, so including accurate minutes and evidence-based outcome letters will become even more important, given that employers might not know if they're going to be face an employment tribunal until at least 6 months after the employee has left. It's also worthwhile mentioning that it will be important to bear in mind that the law as it stands does still give certain day one rights to all employees, and this will continue to apply. The most common example is things like protection against discrimination in regards to protected characteristics like disability, maternity, and automatic unfair dismissal, and protection against suffering a detriment in relation to things like whistleblowing or raising a health and safety concern. So even though we have got this initial probationary or the initial period of employment to come in, employees fairly dismissed during that process could still potentially bring other claims. So always seek advice, always get in touch with us and the team can help. Okay, next slide, please. Okay, so additional practical pointers to consider from a business perspective. What should you do to prepare? Well, at the moment, unfortunately, there's no specific detail, so it doesn't require immediate action, but start having a think about how you currently treat probationary periods and get into the habit of following a fair process with evidence of poor performance. Doesn't need to be a full process, just documentation is key, and address issues with the employee sooner rather than later. And managers will likely need training on probationary processes and monitoring it, picking the staff up if there's any issues and addressing them at the time. And let's see. Yeah, you will also need to be updating policies and procedures, excuse me, but not as of yet because, as mentioned, we need the finer detail and we don't have that yet. But in any case, with the NPA membership, you do have access to contracts and handbook, and they get updated regularly as and when needs. So reach out to us and we can help with that. And finally, yeah, check your contracts. Are they compliant? Are they up to date? Do they reflect the probationary period or this initial period of employment? And does it highlight that they may be subject to dismissal within that without that full process that would be needed after that comes to an end? And also, recruitment processes, I think, are going to be pretty key because consider what they currently are. Do you hire people that are friends of our friends without any reference checks or vetting? Because they will be crucial when it comes to determining, is this person a right fit for my pharmacy? Are they going to be suitable and are they going to integrate well within the rest of the team? And the last point for this, current short-serving employees, so anyone that's less than 2 years service at the moment, potentially have a think about, is there anyone that's maybe unsuitable, anyone that's causing a few issues, anyone that you think, oh goodness, I'm not sure how well they're going to be working out, because address those issues sooner rather than later. Because when this comes into play in autumn next year, it's going to be a lot harder. And if the issues have been unaddressed up until now, you will need to start a full process from the ground up to address them. Next slide, please. Okay, moving on to statutory sick pay. So SSP, as mentioned, will become a day one right for all workers with the removal of the lower earnings limit, which is currently £125 per week. That's the amount the employee needs to earn on average to qualify for statutory sick pay, amongst other requirements. And the removal of that 3-day waiting period where payment kicks in from day 4. In all honesty, it'll make it slightly easier to calculate sick pay, but paying it from day 1, it will have a financial impact. The government has consulted on the percentage rate to be applied for these earnings, or for those earnings below the current flat rate of statutory sick pay. And the outcome of that consultation is that the new level of statutory sick pay, what employees will be paid, will either be the lowest of the flat rate of statutory sick pay, which is currently £118.75, which increased in April, or it'll be 80% of an employee's weekly earnings. So that's for your part-time staff, the staff that earn less, because you shouldn't be earning more for being on sick through statutory sick pay than you would if you were at work. And the biggest impact is likely to be in small and medium-sized businesses whose workers only get statutory sick pay. And with this change, it's estimated that the removal of the lower earnings limit and this becoming day one will enable about 1.3 million people to access statutory sick pay. Next slide. Okay, so considerations here. I would say, again, don't implement anything just now because we don't know exactly when this is going to happen, but nearer to the time, perhaps even an audit. Think about any potential extra costs that your pharmacy is incurring that might not be needed, because when individuals start going off sick, you will be paying a little bit more. Have a think about your systems. Do you have any systems in place, HR systems, absence management systems that would be able to track these sicknesses? And will they be able to implement the SSP from day one? Will they be able to cope with the change? And then policies. I'll be speaking a lot about policies through this, but yeah, it's too early to change those, but be prepared to invest the time to make the changes when it's needed, to roll those out to staff so that they're aware. And also, this one would be extremely important. Well, I think it would be, but have a robust absence management policy in place, because there is a likelihood that some employees in the future will start chancing it, and those malingerers will be taking more sick days than perhaps they might need. And if they know, especially if they know that they're going to be getting paid for it from day one. So if they're not genuine, there can be a formal process in place, if it's not linked to disabilities, where there could be return to work meetings, there could be formal absence management, and they could have warnings that could perhaps build up until dismissal. And even return to work meetings in themselves can act as a deterrent on sickness absences, because if someone's chancing their arm, the prospect of having to sit down with their manager or supervisor and dissect the absence can put them off even doing it in the first place. Okay, next slide. Thank you. Okay, parental leave. We mentioned the family-friendly rights would be looked at as well and potentially become the day one. So there's something called unpaid parental leave that will become a day one right. And this is the right that a parent has to request up to 4 weeks off per child for each year. Currently, you need 1 year service for this, so that 1 year will be scrapped. And then paternity leave and the statutory paternity pay will become a day one right. Currently, you need 26 weeks service for that. And amendments will be made to someone to take paternity leave in addition to and after taking shared parental leave, whereas at the moment you can't take this type of leave after shared parental. It also allows employees to take 1 or 2 weeks together or separately to be taken within 52 weeks of the birth, whereas at the moment you either take 1 week or you take 2. You can't separate it. Next slide. Okay, we'll move on to the last leg of sort of key family-friendly rights and what else is in store. Next slide. Okay, so we mentioned briefly maternity rights earlier on, and the protection for new mothers will be strengthened. The government intends to make it unlawful to dismiss an employee within 6 months of her return to work, except in specific circumstances. And regulations will be needed to define exactly what these specific circumstances will be, because there will be circumstances where dismissal would be merited. We already have strong pregnancy protections in place in regards to redundancies, in that in a redundancy situation, the employee gets priority rights for any suitable alternative role, and that right applies for a period of 18 months from the date of birth, which I mentioned earlier. It could be that this is extended to other situations aside from redundancy, and it may also be extended to provide protection after a period of other types of statutory family leave, so perhaps maybe not even just maternity leave. Okay. Next slide. Okay, and last leg of the family-related leave. So this section here isn't necessarily in the bill, but I thought it'd be a good point to mention Labour's other plans. So they've continuously said throughout that parental leave needs to be enhanced, it needs to be reviewed. And during the House of Commons debate, the government stated it plans to commence a review of the current parental leave system before the bill becomes law. The indication is that the review may begin as early as June 2025, and the focus is on supporting working families. So it's likely that further family-friendly provisions will be introduced, so just watch this space. And then carers leave, the unpaid carers leave was introduced in April last year, and the government has noted that the right to unpaid carers leave, although it had been recently introduced, but that it would review the measures and consider whether further support is required. So is what is in place just now, is that sufficient to support working people who have caring responsibilities? So there may well be changes afoot for this as well. Next slide. Okay, we'll have a look at the collective redundancy consultation, which I mentioned briefly, and the review of the trigger threshold. So highlighted before, the current obligation for the collective consultation, this is triggered when there's at least 20 or more redundancies proposed in a 90-day period at one establishment. So I mentioned briefly earlier, the government had proposed that the reference to one establishment would be removed, making it if you were having 20 or more redundancies across the business within a 90-day period, that it would trigger the collective consultations. But it's listened to the objections that have come back during the consultation process, and the one establishment threshold will still be kept, but instead it's proposing to introduce regulations to introduce an alternative threshold, which would also trigger the obligations. It could potentially be a fixed number, which will be more than 20, or it could be a specified percentage of the workforce. It is expected that this will most likely apply across the employer's whole workforce across all sites, and the government will consult on this alternative threshold and what that looks like. So there's also a protective award for failing to adhere to the collective obligations, and it has consulted on strengthening remedies where collective consultation applies. The outcome of this is that the protective award, will double from 90 days to 180 days actual pay per person. So employers will need to ensure they fully comply with the prescribed statutory obligations on collective consultations when this changes, when it enhances, because otherwise they could pay the price and take extensive compensation for it. So the rules can be complex, but if you reach out, we have a team of dedicated advisors that can help if this is anything that you're facing. So give us a call before anything even starts. And as mentioned, the government will be consulting on what the alternative threshold looks like and how to strengthen collective consultations as a whole. Points to consider for this, again, the financial risk of non-compliance, which we've highlighted, that 90 days up to 180 days. If you're not adhering to the obligations, that can be quite steep. And then have a think about your monitoring systems, if you've got any HR systems, any tracking systems, to make sure that you're aware of what redundancies are going on within the business, if you've got multiple branches or multiple pharmacies, because if there's another threshold here that affects everything across the board, you want to be aware of it and know when your obligations kick in. Next slide. Okay. Another news-catching item was the government's plan to abolish 0 hours contracts, and it was everywhere in the media. It's a complete ban. They're getting rid of them. You won't be able to use them. It's not a ban. But as the bill stands, it does create new rights for employees and new obligations on employers, which are incredibly complex. Okay, so the consultation process on the 0 hours has concluded, but the bill is still going through the House of Lords, so may well be subject to change later. So I'll provide a summary of the proposals as they stand just now. So these rights will apply to qualifying workers. So those will be 0 hours workers and low hours workers. That low hours workers is to be determined. So if someone's maybe guaranteed like 5 hours per week, potentially they could be caught by these provisions. The employer will need to offer them guaranteed hours which reflect the hours regularly worked over a reference period at the end of every reference period. So it's not just one duty, you've offered them the contract and then that's done. You will need to keep tracking this. The worker will have the right to accept or reject the offer during a response period, and we don't yet know what that response period will be. And employers will be required to give workers reasonable notice of shifts, of any cancellations and any changes to a shift, because if they don't, employees will have a right to compensation payment if a qualifying shift is cancelled, moved or curtailed at short notice. And short notice, again, to be confirmed, but is to be defined by regulations, but it will not be any more than 7 days. And employers will be required to provide information to 0 hours workers about their guaranteed hours rights during an initial information period. And as mentioned, it's going to be a continuing obligation to ensure the worker continues to have access to the specified information. So the initial period appears to be 2 weeks, so 2 weeks for existing workers from when this becomes law, then potentially everything will kick in. For new hires, it'll be 2 weeks from their start date. And for any existing workers who it becomes reasonable to consider that they might be caught by these provisions, so they might have gone from permanent hours to 0 hours, then you'll have 2 weeks from when it became reasonable to consider that. Workers will have a right to make a detriment claim on grounds related to guaranteed hours offers and reasonable notice of shifts or compensations for cancelled, moved or curtailed shifts. And this is something which will be an automatic unfair dismissal consideration. So it'll be a day one right that we will have enhanced protection and protection from suffering a detriment or being dismissed, because if the reason or principal reason is that they accepted or rejected or proposed to accept or reject a guaranteed hours offer, or where the employer sought to avoid compliance with its duty to offer the guaranteed hours. So they shouldn't be suffering a detriment as a result of any of these. There was also one point in the bill early on where there was a loophole in regards to agency workers, that this didn't cover agency workers. So it would give employers the option to potentially hire agency workers in the 0 hours relationship, but without having to fulfill the obligations that we've just highlighted. However, after identifying the loophole and following consultation at the end of last year, the provisions have been amended to now cover the agency workers. So the obligation to offer guaranteed hours will land on the end hirer when it comes to agency workers. And the obligation to give reasonable notice of shifts will be jointly held between the agency company and the end hirer. So you're the end hirer if you're hiring the staff through the agency company to come and help you. The agency will be liable for any compensation due for failing to give reasonable notice of cancelled, moved, or curtailed shifts. Although, if there's a pre-existing arrangement in the background, it may allow for the agency to recoup that from the end hirer or potentially you as the end hirer. There's also quite an interesting provision which has been proposed in line with this, which allows employers to contract out of certain rights related to guaranteed hours and shift arrangements for 0 hours and low hours and agency workers. But the only way that you can agree to opt out is if you negotiate this through a relevant collective agreement. So that needs to be with a trade union. So it means the employer would first have to recognise an independent union, negotiate the terms of the opt out, and then also ensure that the terms are incorporated into the worker's contract. This is the only way to opt out of this obligation when it happens, but I struggle to see a situation where a union would be willing to encourage an employee to do that or finalise it unless there was something that the employee was really going to benefit from in return. Next slide. Thank you. Okay, we'll have a look at sexual harassment update. The duty to prevent sexual harassment was introduced in October last year, which placed a new obligation on employers to take reasonable steps to prevent sexual harassment in the workplace. The bill is proposing to extend this from taking reasonable steps to taking all reasonable steps. There's also further amendments in the pipeline, which would be the whistleblowing provisions will be amended so that if someone makes a complaint about sexual harassment, this will amount to a qualifying disclosure. And what that means is that whistleblowers basically have protection from suffering a detriment as a result of making that disclosure, and raising complaints about sexual harassment will fall into that category. Okay. It also means that, amongst other things, that there are remedies currently available to whistleblowers, basically support for them, their benefit. For example, there is something that is called interim relief. This will also be available to someone reporting sexual harassment. Now, interim relief is it's a rarely used remedy and incredibly expensive for an employer. But basically, if an employee is dismissed for whistleblowing, because of whistleblowing, potentially an order can be made, which would mean that the dismissed employee's employment is treated as continuing for pay purposes, and the employer would need to pay that employee, that complainant, that fired employee up to the full hearing, which based on current employment tribunals timescales could be 12 to 24 months. So if that does come into play, that could be pretty expensive, but it's very rare. They're very few and far between. In regards to sexual harassment, specifically third-party harassment, so there's already that preventative duty that employers need to take to protect their employees in advance from sexual harassment in the workplace from colleagues and third parties. But the bill is proposing to extend this to make employers liable for third-party harassment of their employees for all protected characteristics. So not just sexual harassment, it could be age, race, religion, where it occurs in the course of employment, and all reasonable steps to prevent have not been taken, because that's the defence. If a sexual harassment or harassment claim is raised, that you've taken all reasonable steps to prevent that happening. Further regulations will be needed to set out exactly what amounts to reasonable steps, because every single business is different, every pharmacy is different, different sizes, and it's not immediately clear what the difference is between changing the duty on employers to take reasonable steps to prevent this to taking all reasonable steps, and what that will do. But the intention must be to increase the threshold somewhat, and it is notoriously difficult for employers to show they have taken all reasonable steps when defending discrimination claims. So it may be that this will also occur here. Next slide, please. Okay, and it is that time of year again where all national minimum wage is reviewed and increased, and statutory payments go up as well. So in July 2024, the remit of the Low Pay Commission was changed so that it will take into account the cost of living when making recommendations for minimum wage levels, and it will gradually narrow the age gap for 18 to 20-year-olds, so that eventually there will just be one single adult rate. For example, like those aged 21 and over. This was also mentioned in the King's speech back in July last year, when he proposed to work towards removing the discriminatory age bands for national minimum wage. Currently, the government intended the apprentice rate to stay the same, and the previous rates and those from April 2025 are on the slide. So I'll leave them there for a little moment. Okay, next slide, please. Right. So coming to the end of our update regarding the Employment Rights Bill and the national minimum wage pay changes. So we'll summarize a few key takeaways and action points for businesses. But as I've been saying throughout what we've covered, it's not anything you need to panic about right now. There's policies and procedures to be updated in time, potentially training to be implemented, but we need more information. The bill has not received royal assent yet, and there will be further changes, so the finer details still need to be ironed out. But this is something that will impact across all business sizes, all sectors, not just pharmacies. And these are key changes, and they're big changes, and it will impact everyone. But stay calm, don't panic, and as mentioned, further guidance is needed to iron everything out. But I'm not saying don't do anything, I'm just saying perhaps maybe from a business perspective, be proactive, have a think about, what the changes are. Keep an eye on the bill's progress in the background and have a think about how your pharmacy could handle the changes, how you can adapt and overcome them, and when they come about. Also, yeah, it'll be policies, procedures, and contracts that'll need to be updated as and when. So you'll need to be thinking about getting them up to date when we have the dates of implementation for each of the changes. I've said this earlier on, but address issues sooner rather than later because you don't want to leave them to the point that it becomes an issue and you've got employees that have got long service that have been doing the same mistakes for years and they've gotten away with it and they think it's completely fine. And now it's a problem when it starts getting dealt with. Equip managers, your managers, your supervisors appreciate that many of you are running busy pharmacies and managing staff at the same time and you can't be in everywhere at once. But perhaps could you delegate responsibilities to senior staff? Could you train them up on managing performance, on managing probation periods, get them to know what they need to do in terms of documenting, reviewing, because it could take some of the pressure off you as well. And then start promote new habits and best practice. And then use reliable information sources. There is an abundance of information out there, but focus on credible updates. The Parliament government website is great, and the parliamentary process I highlighted before. The bill is extensive and it requires a great detailed analysis. I mean, we are lucky enough to have a resource of professional support lawyers who they are dedicated to studying the legal changes, the updates, and they are pivotal in our updates as well. So if there is any queries that you need, reach out, get in touch with the NPA, get in touch with ourselves, as the partnerships team, we can help with the employment law updates and we can keep you accurately up to date with the queries as they progress. Okay, and next slide, please. And just wanted to move away slightly from the bill and just highlight the benefits that you get as being an NPA member and how we at WorkNest can support you. Okay, so as an NPA member, all members benefit from the support of employment law advisors and health and safety advisors. We have a wealth of resources and knowledge across us all. It is team advice that you benefit from, and it's via telephone and email. We have got a fantastic range of health and safety, employment law documents, freely accessible from contracts and handbooks to recruitment documents, disciplinaries, and risk assessments, to name just a few. So my team specifically are on hand to help you with any employment related matters. So do always give us a call in the first instance because we can help discuss the situation because they are scenario specific and every employer is different. Everyone's got a different way of working. We can get the background with you and we can help you make informed decisions regarding safer options, more commercial options. But ultimately, it's your decision at the end of the day what you want to do. But let us give you that advice and that information so you can make that informed decision. And you also benefit from the NPA portal with your membership, which has access to lots of the resources that I've mentioned. And if you log on, you can download them there, from blogs to articles and some of the documents that we have as well. There are additional benefits that you can gain through the portal, but you just need to fill in a little form for them. And that's things like having access to a document storage facility and even access to a trial of our e-learning courses for you and your staff with completion certificates. And then you've got the option if you think this is something I want to keep doing, you can get the full e-learning package. Okay. So if there is anything that you do need, any queries that you have, the contact number is there. The email address is on the screen. And next slide, please. Okay, so we do have some time for some questions in regards to employment law before we hand over to Nick and open it up to the entire forum. So we'll see what's come in during the time that we've gone through this.
So Alice, I don't know if you can see the Q&A, if that's okay.
Apologies. Let's have a look-see. Where are we? Oh, baby second. Okay.
So Alice, do you want me to pick up the Q&A questions that have come through and ask them to you? Is that okay? Because there's a couple for
Yeah,
some of
that'd be
the
fab.
other panelists, but if I pick up yours first, and then I think I've got one for Gareth and one for Seth as well. So if I and then I've got a few more that somebody is coming in as well. So the ones on the Q&A we've got, I think, for you, Alice. So day one rights.
Yep.
What about the role of a probation period?
Okay.
Was asked. So how does that work and fit in with the day one rights and probation periods? Can you sort of give some thoughts on that, please?
Yeah, certainly. So the day one rights, it's not saying, I know it's quite scary to hear unfair dismissal will become a day one right, but that's not to say that employees will be untouchable. It just means that there will be that kind of period where you can make an assessment, and anticipated to be 9 months just now. And as long as you're making a decision on their employment on the grounds of conduct, so like disciplinary matters or performance, or even illegality. So say if you have a delivery driver, they lose their license and it would be illegal if they were continuing in that role. If you're making a decision on their employment within that potential 9 months period, you still can do it. It just means this lighter touch process, which potentially the bill talks about, it would be at least a conversation where you highlight the concerns. They have the right to be accompanied. And if there's no contentious issues in the background, like disabilities or anything like that, yeah, dismiss, get your outcome letter in. I would just say evidence gathering is key because tribunal claims are going to go up. You want to put yourself in the best possible position because to defend it, if anything does get raised, because they can be extremely time consuming and costly.
That's really, really helpful. And another one, I think, for you, Alice, are there any, because I think this is a bit of crystal ball moment, I think, are there any more increases in NMW, which I think is national minimum wage, planned in the near future? Any sort of insights or thoughts on that?
Well, national minimum wage tends to increase roughly every April. I mentioned earlier on the King's speech last year, he'd highlighted, look, these difference in age bands are discriminatory, and you can certainly see with the changes now, the gaps between them are getting smaller and smaller, and some have jumped up quite steep. So my thoughts are that potentially at one point in the future, maybe not next year, the year after, but we will end up moving towards that one rate for adults, and then potentially it would be good if we still had an apprentice rate because it's a different relationship, but watch the space. The national minimum wage rate does go up every single year along with inflation and national insurance. Just keep an eye, but it's around about April time.
That's really helpful. Thank you.
Right.
I've got one for Suth, which I'm going to ask, and then I'm going to come back to you, Alice, if that's okay. So I've got one which somebody's actually texted me, which is asking me if OptiTote is available across the entire estate, or is it being rolled out in phases across Alliance Healthcare? So it's actually come in from one of my colleagues in the Southwest. So is it universal across the estate, or is it sort of being phased in different places? Because it looks a really interesting proposition, was what I've been asked. So.
Yeah, no, that's a good question. No, it's we've had some test sites and that have been really successful. So we are ready to actually roll out universally with everywhere, to be fair. As long as the criteria are made, and then again, we can have a bit more of a detailed conversation, do some demos. But yeah, more than happy to take that in detail. But yeah, we are ready to roll that across. We've had some test trials which are positive. So yeah, we're ready to go.
That's really good. And the one I've got again, so just come to me about the switch. So switch is embedded into PMR, or is switch something different? So can you, if you use transmit and order, can you have it embedded and transmit, or is it a separate piece of process that needs to happen?
It's a separate piece of process. However, the web page switch could be added onto your PMR system. It's kind of like where you got web browsers as a tab, so you can have that as another tab. So it's integrated, but not entirely, but it's right there. So it's the ordering process made a lot easier with that in. So
yeah, that's really, really, really helpful. Thank you very much for those. So
no
really
problem.
answers, no problem. I think we've got another one coming in for Alice, but Gareth, I'm going to go to you and then go back to Alice again, if that's okay. So I think one of the first questions in when you were speaking was there's a question in the stop about the percentage of share of primary care budget, historical and 25-26. If I can hand that over to you, is that okay?
You can do, and if Helen's able to put the slide up, it's easier to answer this one, from the slide. So this is some data I found from the Nuffield Trust, and it does actually answer the question. So what you can see here is real term spending in the NHS, so the period for which data is available is the period 2016 to up to 2023. So not quite up to date, but more as far as well, the most up to date data I could find. So you can see, so what they've done here is recalculated every year based on the same value of money. So the increase you can see is actually a significant increase in total NHS spending over that 6-year period. So in fact, it goes up over 20% in real terms over that period. So inflation plus 20%. So you can see at the top, the big blue band is acute trusts. So their funding went up over that period from 52 billion to 68 billion. So that was 55% of the NHS total spend, up to 59%. So over that period, the acute trusts have been taking a larger share of all NHS spending. Then the yellow line in the middle is primary care, which essentially means general practice. So over that 6-year period, their funding went up from 8 billion to 9.7 billion. But that was exactly an 8.4% share of NHS budget, both at the start and the end. So general practice didn't get a larger share of the NHS cake, but the NHS cake got an awful lot bigger over that period. So in fact, they saw a 20% real terms increase in funding over that period. And then the tiny line at the bottom in purple represents optometry and pharmacy. They're grouped together because our funding is so small. We were grouped up with somebody else when it's shown on this graph. In 2016, optometry and pharmacy, and bear in mind pharmacy is the majority of that spend, was getting 2.6% of the total NHS budget, and at the end of the period it was down to 2%. So that was very clearly a real terms cut. So, in brief, over that period, acute trust taking far more of the share of NHS spend. General practice kept about the same share, but community pharmacy was losing.
Okay, Gareth, thank you. Really detailed answer, and maybe that's really helpful and really useful if we're talking to other sort of decision makers, both locally as well, about what that might look like. So that's really good. Sutha, I have got another one for you. I'm going to come back to in a minute, but I'm going to go to Alice if that's okay. So another question we've got come in. So if someone have a job role change, can we reintroduce a probationary period in that new role? So, I'm the chair. I'm now the immediate past chair. Gareth can then kick me out and my probation period starts again. It's something like that.
I'd say I love this answer because it always depends. Potentially, yes, you can. Sorry. At the moment, before the unfair dismissal rights change and become day one, technically, yes, you can, because less than 2 years service, you could jump to dismissal without following a full fair process. You just need to be mindful of those other claims in the background, like discrimination, disabilities, pregnancy. So technically, for now, you could have probation periods 6 months. Okay, you've passed it, you've done well. We're going to give you another role, but with that, subject to a probationary period, and you could certainly dismiss them within that period. But if they're over 2 years service for now, you could still put them in a probation period, but it wouldn't be safe to dismiss them straight away in that manner without going through investigations and following the right process, whether it's disciplinary or performance. And then when the day one right comes into effect, after they get past this potential 9-month period, it'll be the same thing. You can put them back in a probation period, but it wouldn't be safe just to jump to dismissal because that would pose as a risk.
Okay, that's really helpful. I've got another question that's been sent to me as well about 0-hour contracts, which I might ask you just in a minute or two. But so the question we've got again is about costing on switch. So we've obviously piqued some interest on that. So if there's anything you can share, or it may be commercially worked out at different places, but maybe you could share something.
Yeah, no, definitely. As with anything, there is a cost with switch. However, the way we design it and way we can commercially approve it, we can work into ways to kind of build in something where it doesn't actually cost anything. We'll obviously set that up depending on the account, and we can kind of look into a bit more detail. So, for example, we have some accounts where we would ask for the ethical and branded lines to be fixed and everything else cascaded. And as long as you use the system, 70, like a compliance, 60 to 70%, which doesn't mean 60 to 70% alliance before everyone, their breath. It is just using the system 60 to 70% of the time, and then the system can be given for free. But a lot of our users also adopt to pay for it because they just like the system and they just want to use it to their needs. So definitely able to do either pay for the system or you can get it free. So happy to have that conversation offline with anyone if they would like more details.
That's great. Thank you very much. And again, you knew what question was coming next. Well, the question is how much. I'll let you think about that. But maybe you think, I think what you're saying is bespoke depending on compliance.
Yes.
So the best thing to do is email the stuff that you said in the slide pack and get a quote from your rep. Yeah.
Yep, exactly. Yep, that's it. Thank you.
Brilliant. Thank you. Alice, I'm going to come back to you, I think, I've got maybe one or two more, and then I think we're going to be closing up in the next sort of 5-6 minutes, if that's okay. So
Yep.
the next one I've got would be what steps would employers undertake to ensure dismissals remain legal and compliance once the day one right is implemented?
Yeah. I think just make sure that your managers and your supervisors are trained that they can monitor this. I know we talked about a lot of this earlier on, but recruitment, your onboarding process, make sure the staff from the get-go are aware of the expectations of the job so that they don't come round later on and say, oh, I had no clue that I shouldn't be doing that, or I didn't know what your standard operating procedures were. Make it clear from the beginning, they know, they've understood, and then pick them up at the time of the issues, because quite frequently I speak to businesses and employers where they'll say, we've had the informal chats. Like, it's good having the chats, but document it. Because if you're continuing to pick them up for the same issues and they're still doing it and you're in a position where you think you're going to dismiss, but if they're now pregnant or have a disability, they could link the dismissal to those because it's not been addressed beforehand. But just when it becomes day one, document, bring it up at the time, make sure there's no contentious issues in the background that's a cause for these failings, like a medical condition. And yeah, potentially a conversation with them, go through the concerns, have someone accompany them. And if there's nothing contentious, dismiss with the outcome letter, making it very clear the reasons for dismissal. So they can't then say, oh, well, you dismissed me because I told you I had a disability. I said, no, we dismissed you because of all these conduct issues that aren't linked. So yeah, put yourself in the best position with your evidence.
Okay, so then I've actually got two more that have come in, and we're conscious we've got about 7 minutes. So I'm going to try and get them both in, Alice, if that's all right, for completion of the people that are attending. So there's something there about the requirements of reasonable notice and the compensation for cancelling shifts under 0-hour contracts, and how may actually sort of deal with some influence around operational flexibility, staffing costs, that kind of stuff.
Mm-hmm. Well, we don't know what the compensation is going to look like yet, or the time frame for when you get past that threshold. That's when the compensation kicks in for the changes, but it is going to impact businesses that have the 0 hours. So have a think about cost saving. Is there any other measures within the business that you could address to try and have a little bank in the background just in case this happens? Could you change suppliers? Is there anything else that could be changed? I'm trying to think. Potentially review your practices, see if there's a theme. Do you need a bigger bank of other staff that are willing to pick up hours short notice? Can you change the shifts longer in advance? Can you prepare more? Review your rota systems? Those kind of things. But we need the finer detail to know exactly.
That is really helpful because from a business and operational point of view, they're really useful. Before I ask you the last one, Suth, have you noticed there's somebody's email in the chat? I don't know if you can email them directly, then maybe point them to the appropriate representative. That's the person that was asking about Switch. Is that okay? Have you got that? Yeah, thank you.
Yeah, no problem. Yeah, I've got that.
Really
I'll
appreciate
email
that. I didn't want that to get lost for both the member and for you within that process. Thank you. Lastly, in the last 5 minutes, so considering the changes related to sexual harassment, obviously you talked about reasonable ends and stuff. What sort of specific action should be employers attempting to sort of prevent any sort of claims of sexual harassment in the worst place? Given you said about all reasonable steps needed to be taken, what are the things we can do maybe to help us not get in that situation?
Yeah. Perfect. That is a good question because since everything changed in October last year, we have had an influx of queries, which has then prompted staff coming up with historic incidents that they've maybe not felt comfortable enough to disclose before. So, from a business perspective, I would say risk assessment first. And we've got template risk assessments we can supply you as a starting point. Every business will be different though. And that'll be thinking about where are the risks? Do we have lone workers? What's the exposure from my staff to third parties to contractors? What about my delivery drivers when they're going out to deliver medication and the members of the public that they come into contact with? Risk assessment and then the results of that. I would say an action plan, assess where the high risks are and think about what steps you can take to minimize that. So if you've got staff that are working by themselves with members of the public, could you review their hours where there's maybe less of an overlap? If they're lone working, can they check in with someone at certain times? And do staff know how to report things in a safe environment so without fear of repercussion? Because then if you know about it, you can take appropriate action to investigate it and act accordingly.
That's really, really helpful. Thank you. Lastly, I think I just need to say thank you very much, Alice. I noticed that, there's that huge team of WorkNest which you're working with, and you've articulated a really difficult subject really well. I've learned an awful lot. Thank you for answering the questions. And it's really great to know that our members have an access to such a wide team in the background, which is amazing. See some of the stuff you're doing with Alliance Healthcare, trying to free up time, really innovative. And thank you very much again for sponsoring this evening. Gareth, you know how proud I am of the team on the campaigning, but thank you for everything you do and all the stuff back there. I think is so important, highlighting all that stuff for members. I have noticed since Olivier's taken over as chair, my picture was me on radio and he's on TV a lot. I think that says a lot, but I'll pick that with the team later. I have the face for radio, he has a face for TV, obviously. And Sabrina and Helen, who do all the hard work in the background. Thank you all. Thank you for giving up some time this evening. We look forward to seeing you at the next event. Thank you very, very much. Have a great evening. Thank you.
Thank you.
Thank you.